Recording in progress.
Good morning, Masi. It is now 10 o'clock. Can you confirm whether we have enough members to proceed?
Good morning, Chairperson. Yes, we can proceed, Chairperson.
Good morning, members of the Committee of Public Service and Administration. Let me just take this opportunity to welcome all honourable members and staff present for this committee meeting. Let me also take the opportunity to specifically welcome the delegation from the DPSA who will lead us today on this workshop. But before we start, can I just ask the committee secretary to just project the agenda for us, please, for the adoption of the agenda for today. If we can just have the agenda, Masi, on flighted. Thank you very much. We can see it. Members, as you can see, it is the orientation workshop on the Public Service Amendment Bill and the orientation workshop on the Public Administration Management Bill that are the two main items of this agenda. We will have an opportunity after both these bills to do the deliberations, and we very much look forward to it. Can I please have any nomination to adopt the agenda as it is flighted in front of us? If any member would be so kind to just give us ask for the adoption of the agenda. I think I must send coffee to my members. Members, can I please have just a nomination to adopt the agenda? I see a hand from Honorable Nkobo. Please go ahead. Honorable Kaba.
Morning, Chairperson. Morning to the honorable members in the platform and the department. I rise to adopt to move the adoption of the agenda, Chair.
Thank you very much, Honorable Kawa. That is much appreciated. Members, is there any other member who would like to second the adoption of the agenda or register any objection? If I receive no objections, then I'm happy that we can move ahead with the agenda. I see in the chat group that there is a seconded on in the text. But members, it really is a simple agenda today. We will be making no decisions. We will just be enjoying the workshop from the DPSA. I would like to just open the floor now for apologies. Members, I have received an apology from the Deputy Minister, who has indicated that she cannot attend today. But I must just say, I think as a committee, we maintain a good balance. I think we expect the Minister and the Deputy Minister to be in our committees when we deal with items where we need their inputs as the heads, as the executive in those departments. Today really is just a workshop about legislation, and I don't think that their presence would have been necessary here. But nonetheless, the Deputy Minister has sent an apology, and I gladly note that. We've also received an apology from Honourable Letlape, who's just indicated that he is in the Health Committee. He might be joining us later. We have a standing apology from Honourable Spies, who we know is still on leave due to a medical operation which he had. And is there perhaps any other apologies which I must note, members? I see no other hands, so I will then assume that there are no other apologies to note. Thank you very much. Members, as per our approved program for this quarter, we were supposed to deal with lifestyle audit presentations today from the DPSA and the SIU. However, the department has humbly requested shifting the meeting, which we acceded to and replaced it with a workshop on the bills passed during the 6th Parliament, and which is now in the NCOP. So, members, we just swapped 2 slots in our program around, and we will still deal with the lifestyle audits from the DPSA and the SIU at a later stage, and we will also send you the updated program. The department is engaged with the G20 on the public administration reforms. So, as I said, we took a decision to replace this meeting with the workshop aimed at empowering members about the Public Service Amendment Bill and the Public Administration Management Bill. This workshop will empower the committee about public administration reforms and readiness in case the NCOP has made amendments, which might be referred back to the committee. With those few words, let me allow the department to take us along the presentations on both bills and perhaps just give us an update on where exactly the process is in the NCOP and what we can expect going forward. With those few words, members, I'm going to hand over to the department so that they can start with their presentation.
Good morning, Chair. Good morning, honorable members, and good morning, colleagues. My name is Rosita Amaidas, and I am, as you've indicated, as part of the delegation. It is a 2 or 3 person delegation that will be presenting on the Public Service Amendment Bill and the Public Administration Management Amendment Bill of 2023. Chair, with your permission, I just want to, my colleague, Dr. Foromo, who is presenting on the Public Administration Management Amendment Bill, he is also engaged in another meeting today. Will it be possible if he could present first on the Public Administration Management Amendment Bill? Is that in order with the Chair?
Yes, absolutely. That is not an issue. We can just swap those 2 bills around. Please proceed. And thank you for turning on your camera. You are not audible at this stage. We unfortunately can't hear you. I see that your microphone is unmuted, but there's no sound coming to us, which probably means that on your system somewhere your microphone isn't turned on, or your headphones might not be working as they're supposed to.
Okay, all right, I'll do so. Okay, thank you. Bye. Chair?
Yes, can we please have an update on what's going to happen?
Yes, I've just called my colleague, Dr. Foromo. He said it's fine if I proceed with the Public Service Amendment Bill while he sorts out his audio.
Okay, maybe send him a text message that he can turn off his video in the meantime.
Okay, I'll do so.
Okay, thank you. Please proceed.
I'll do so. I just want to let him know.
He has turned off his video.
Okay, perfect. Let me share screen. I just want to confirm that my screen is visible. Chair?
Yes, absolutely. Your screen is visible. Thank you. You can proceed.
Thank you for confirming. I will start off just with an overview of both the bills and what happened in a slide or two. That's just the processes that were followed. Just want to do this part. I just also want to indicate just the format for the presentations for both of them. What we have done is we have indicated the clauses in the bill. We refer to them, and then that is followed by a slide which will show the actual depiction of the actual provision, where there are three columns. On the left-hand side is the provision that appears in the Principal Act. The middle row is column, is the amendment as it appears in the bill. And so that which is underlined is insertions in the bill, and that which appears in the brackets are deletions. And then on the right-hand column, it's how the amended provision reads in the bill. So just as a brief outline of the processes that we have followed to date, both bills were published for public comment in the Government Gazette on 6 April 2021. We received public comments, and these were considered for possible inclusion. The bills were also extensively consulted at the bargaining councils during April 2021 to July 2022. NEDLAC engagements were then concluded in February of 2023, and the parties at NEDLAC agreed to the redrafted bills. The bills were then submitted to the Parliament on 31st of March 2023. And on the Public Service Amendment Bill, the Portfolio Committee made changes in two clauses, that is the A list, and adopted the amendment bill on 14 February 2024 and referred it to the National Assembly. Then on the Public Administration Management Amendment Bill, the Portfolio Committee then made changes in five clauses, that is the A list, and adopted the amended bill on 14th of February 2024, and also then referred it to the National Assembly. The bills were then adopted by the National Assembly with amendments on 27th February 2024, and it was presented to the NCOP in the B list. The bills were then revived and referred to the Select Committee on Cooperative Governance and Public Administration on 30th of July 2024 by the NCOP, and this followed the elections. So briefings to the provincial legislatures and public hearings in the 9 provinces on the bills were concluded on 9th of June 2025. The Select Committee then held virtual oral hearings and written public submissions on 22nd of July 2025 regarding the bills. And the department then provided written responses at a physical meeting on the 2nd of September 2025. The department then also received negotiating mandates from the provincial legislatures and provided written responses to the Select Committee on 10 September 2025. At that same meeting, each provincial legislature also tabled its votes in the negotiating mandates on the bills. And following the tabling of the negotiating mandates, the C list of the Public Service Amendment Bill was tabled at the Select Committee on 16 September 2025, and the respective provincial legislatures adopted the C list. No amendments were required on the Public Administration Management Amendment Bill, and therefore a C list was not necessary. Just to indicate, there was just one spelling mistake on the PAMA bill, as I will refer to it, and that will be rectified when it goes to print. The D list on the Public Service Amendment Bill was adopted on 14th of October 2025, and the PAMA bill was then confirmed on the same day. Just to add what took place on Monday, this 27th of October, the final mandates or negotiating mandates were tabled, and the D list of the bill on the Public Service Amendment Bill was then read into the record clause by clause. And then also the committee reports were tabled, and these were adopted in the, this was followed by the ATC of 27th October 2025. So regarding the Public Service Amendment Bill, just to give context on the bill itself and what informed the amendments, the process to amend this Public Service Act, which I will refer to as the Principal Act, was initiated in 2019, and it adopts a holistic approach to public administration, looking at the various pillars of public administration, which are the citizens, government, service, and the employees in the public administration. Then the genesis, or that which informed the amendments to the Public Service Amendment Bill, arise from, among others, the National Development Plan, changes in labor legislation and policy, the objectives of the Single Public Administration Initiative, the professionalization framework that was approved by Cabinet in 2022, as well as the response plan of the President to the Zondo Commission report. Clause. So now I will just go through each clause. So clause 1 seeks to, it deals with definitions, and it seeks to amend section 1 of the Principal Act, and it proposes amendments to the definition of executive authority to clarify the powers of the President and Premier in relation to heads of departments. The reason for that is that it created interpretational challenges in the past as to who the President and Premier is in relation to the heads of departments. So that is to clarify their role and their powers. Then amendment to definition of head of department for ease of interpretation to remove the reference to acting HOD. It also added a new definition of political office for purposes of clause 16. which I will refer to later, which deals with the prohibition of heads of department and employees reporting directly to a head of department from holding political office. So political office is also limited and defined as the position of chairperson, deputy chairperson, secretary, deputy secretary, or treasurer of the party, nationally or in a province, region, or other area in which the party operates, or any equivalent position, irrespective of the title designated to the position. So in respect of this definition, for noting by the committee, is that this is one of the amendments on the bill at the D list, where the definition has been expanded on. It is now also including, after treasurer of the party, to also include membership of a party's executive committee. So that is one of the amendments that are in the D list to note. It was one of the major ones. The rest of the amendments to the D list refer to typographical errors and the like. So they are not major changes. This is the only sort of a big change that was effected in the D list. So as I've indicated, this is these slides have been included for your ease, and I've explained to you already that this is the current provision in the Principal Act, how it appears. This is the amendment in the bill itself, and this is how the amended provision reads. Chair, with your permission, I will not go through each and every slide because this is a lengthy presentation, but is subject to your decision. I will not go through each and every slide because it's quite cumbersome, and we have provided this, but it is your decision to decide whether you would like me to go through each amendment.
No, I absolutely support your suggestion. The presentation was circulated to members. I think the important thing is to bring under our attention the amendments that has critical impact, that amendments that made a difference to the bill, not amendments that are basically of a technical nature. So if there are any amendments which you feel might have changed a meaning, or in some way impacted the bill, made it stronger or weaker, whatever the case might be, I think that's the more important amendments for us to be highlighted.
Okay. Thank you, Chair. The definition of political office that I referred to in the earlier slide, that is one of the main or the only amendment of significance, and it emanated from the public participation process at the provinces, as well as the oral and written submissions, where an expansion of that definition was requested, and the parliamentary legal advisors and the Office of the Chief State Law Advisor, in conjunction with the department, then amended that definition to include membership of a party's executive committee. These are slides also referred to the amendments. I've already referred to the new definition, but this definition now has been expanded and amended, as I've already indicated. This is also one of the amendments. This is an amendment to Clause 2 of the bill, and it deals with the functions of the minister and executive authorities. And basically this section deals with the minister's power to make norms and standards on various matters. And the insertion was only at Clause J, where it is reflected as an addition to the Act, Principal Act, to indicate any other matter to improve the effectiveness and efficiency of the public service and its service delivery to the public. Then what is significant, but there are no changes to these, no amendments to these provisions. But just to give you context regarding the powers of executive authorities and powers of HODs, that will be reflected in the ensuing slides that deals with the devolution of powers from the executive authority to heads of department. These were informed by Chapter 13 of the NDP, that deals with building a capable state. And the NDP made certain proposals based on a diagnostic report which identified weaknesses in governance structures in public service that led to uneven performance at local, provincial, and national government levels. This including tensions in the political administrative interface, which causes instability in administration, and therefore proposed that the political administrative interface must be stabilized and clarified to ensure a clear separation between the roles of the political principal and the administrative head. So the bill then went on to identify and delineate certain administrative powers to ensure that operational matters are at the level of the HOD, and strategic powers and policy making still resides with the executive authorities in terms of its constitutional mandate. So this approach is crucial to achieving an efficient and professional public service. It is part of the professionalization of the public service initiative in terms of the professionalization framework. It is crucial as the executive authority is now, based on the devolution of powers, he is now going to be unburdened of routine day-to-day administrative matters. Executive authorities are then able to focus on strategic matters and their constitutional obligations. Decision-making is closer to the administration and not dependent on delegations. Accountability is enhanced if both administrative and concomitant financial responsibilities in terms of the Public Finance Management Act, if they are located in one place as heads of department, and accounting officers are then better able to align budgeting processes to HR matters if they are vested with powers in respect of both the Public Service Act and the PFMA. Also, the conflicts and tensions that sometimes arise between the executive authority and the head of department or accounting officer is less likely to impact on the administration of the department. And the head of department or accounting officer is then ultimately responsible or accountable for the output and the performance of the administration of the department concerned. So in terms of the PFMA, it already vests powers of accounting officers, which are with HODs, and the bill is then proposing the same by vesting administrative powers now with HODs. Then we have this diagram just to make it a bit, I missed a slide. So in order to ensure that the devolution of powers from executive authorities to HODs are soundproof, certain checks and balances were included in the bill. And these are to ensure there are accountability mechanisms in place and to ensure that there's a balance of power between the executive and HOD. So the checks and balances are that the head of department is then to be accountable to the executive authority for the administration of the department and the functional area of his or her responsibility. The head of department must then report to the executive authority as and when required. The head of department is then to assist the executive authority to fulfill the executive authority's accountability obligations in relation to the department and the constitution. And if the head of department refuses or fails to fulfill a power or duty as required in terms of the Act, which is the Principal Act, the executive authority may intervene by taking appropriate steps to ensure the fulfillment of that power or duty. by issuing written instructions of steps to be taken. And if that head of department fails to take such steps, the executive authority must report such failure to the president or premier, as the case may be. So during the portfolio committee process, it read may report such failure to the president or premier, and based on the deliberations at the portfolio committee, it was decided that it must be amended to read must report such failure to the president or premier, and that was reflected in the B list of the bill. Then regarding this diagram here, just to explain this diagram. So the diagram deals with administrative and executive and administrative powers. So the triangle on the left side of the slide are all those constitutional obligations that fundamentally rest with the members of the executive. Those coordinating the functions of the state, preparing and initiating legislation, implementing legislation, developing and implementing policy at national and provincial level, and performing other constitutional and legislative functions that are still vested with the relevant members of the executive. So the triangle on the right-hand side of the slide depicts the following. The red fields are the powers that will vest with the executive authority in terms of the Public Service Act, the Principal Act, which is approving the strategic plan of the department. The dark blue fields are those powers that already vest with HODs in terms of the Principal Act, which empowers an HOD to deal with the training of staff, labor relations, and discipline management. And the light blue fields on the right-hand side, those are powers that will vest directly with HODs in terms of the proposals in the bill. And that includes the recruitment and appointment of employees, the remuneration and career incidents of employees, performance management, dismissal or retirement of employees, transfer of functions within the department, human resource planning, organizational structures, and establishment and approving RWOPs. So those are the ensuing slides that I will refer to. I will indicate that those are the powers that clauses that reflect the devolution or vesting of powers with HODs. So clause 2 deals also with the functions of ministers and executive authorities, and it has been amended to reflect in detail now what the powers of the executive authority are following the devolution of powers, and that is reflected in this slide. Then on this slide, deals with clauses 2 and 3, and it is proposing that section 3, subsection 8 of the Principal Act is moved to section 5(9) and includes a power for the HOD to deal with matters of former employees that he or she would have been competent to manage when they were employees in a department. So in this regard, it creates a new section 5(9), and it's one of those provisions that vest powers with the HOD. So the provision stays the same. If we look at the slide, the provision stays the same, and it empowers the HOD to manage people or former employees who have left the department. So this provision is just basically moving to section 5(9) so that it falls within the context of and aligned to section 5 of the Principal Act that deals with executive authorities. This clause 2 also is a new provision. This is one of the checks and balances that I referred to in a previous slide. It is stating that if the HOD does not fulfill any of his or her administrative powers, then the EA must intervene in this regard. I have already alluded to the amendment that was done by the Portfolio Committee, and that was reflected in the B list. Then clause 4, it deals with public service departments and heads of departments, and it proposes a amendment to section 7, subsection 3A of the Principal Act. It is amended to align with the amended definition of head of department, as is seen in this slide over here. Then at clause 4 also, it sets out and it proposes amendment to section 7, subsection 3B, and sets out in detail the powers of the HOD, which includes performing all duties necessary to support the EA's responsibilities and manage the department and its employees. And this is one of the devolution of powers reflected in section 7.3b. As you can see now, all of these powers that were depicted in the triangle, the diagram, are now here in the amended provisions. Then at clause 4, it also proposes to amend section 7.3, subsection 3C of the Principal Act, and this is a new provision in the bill. The NDP reflects that there should be an administrative head who has oversight over operational and administrative matters at both a national and provincial level. And the NDP refers to it as the head of public service. So Directors General would then report on operational, organizational, and administrative matters to this national head of the provincial HODs, will also refer to the provincial head. So in the Act currently, there's already a provision in the Principal Act which allows the DGs of every office of the Premier to play that operational and administrative coordinating role. So what was missing in the Principal Act is a similar provision at national level to allow for that coordination by the DG. We have also legislated that the DG in the presidency is that coordinating role. And we have also set out what those powers are, and those include the DG in the presidency to be the secretary to the cabinet, to coordinate, convene, and chair the Forum of South African Directors General, FOSED, comprising of all heads of departments listed in column 2 of Schedule 1. These functions are currently already being performed by the DG in the presidency. Then thirdly, subject to sections 85(2)(c) and 125 subsection 2 of the Constitution, they will also be responsible, or the DG in the presidency will be responsible for intergovernmental relations on an administrative level between the presidency and national departments, provincial departments, and government components, including the coordination of the actions and legislation. Then they will also support the president on any matter entrusted or assigned to the president by or under the Principal Act or any other law, and perform any other function if so requested by the president, subject to the Constitution on any other law. So that is the reflection of the amendment in the bill. This is also just a consequential amendment following the establishment or the creation of the head of public service in the proposed 7.3c. Then clause 5, it is dealing with appointments in the public service. It proposes an amendment to section 9 of the Principal Act, and is one of those provisions that reflect the devolution or vesting of powers with an HOD. That is reflected in this slide. Clause 6 is the same scenario. It is also one of those powers that are vested now with the HOD in terms of the bill. to deal with appointments on probation, and that is reflected in this slide. Clause 7, then also dealing with transfers within the public service, is also one of those clauses that deals with the vesting of administrative powers to an HOT. That is reflected in this slide. Then clause 8, change in employment capacity. It proposes to amend section 14A to provide for the continuation of employment when a person employed by an organ of state is appointed in terms of section 9. An insertion is proposed to retain section 15 subsection 1, which is being repealed by the Public Administration Management Act, to ensure that certain benefits of employees who are appointed from other organs of state are protected. So during the legislative process, so what happened here was that during the legislative process in 2014, when the PAMA was enacted, one of the things that the PAMA did was that, which is the Public Administration Management Act, it was that it repealed section 15(1) of the Public Service Act. And in repealing that, it took away the authority of the state to ensure that when employees of organs of state are appointed in the public service, that they don't lose their years of service in the public service. So we are therefore just suggesting that this clause be reinserted as section 15 subsection 1 in the Principal Act, and we are doing this by indicating it at the new amendment to section 14A. So, and that is reflected in this slide. Clause 9 deals with the retirement and retention of services. This is also one of those proposals to vest administrative powers with the HOD, and it also amends section 16 to substitute the term officer with a defined term employee. So this was an omission, to amend an omission that comes from years back, because officer was an old definition and was replaced by employee when the Public Service Act was initially amended. And the amendments affected by the substitution of the terms are these amendments to section 16 that are reflected in the ensuing slides. I will just skip those slides. Then clause 10 again is a repetition of one of the provisions that are vesting with the HOD, and deals with, it amends section 16B subsection 6 to prohibit a head of department from agreeing to a shortened notice period for resignation in instances where an employee wishes to resign after notice of disciplinary hearing was given against the employee. So that is indicated in this slide. Then clause 11 is also one of those vesting of powers to provide for a head of department with the power to dismiss an employee. That is reflected in this slide. Then we go to clause 11, also amends section 7.3b. That is also one of the vesting of powers to an HOD. It deals with termination of employment, and also provides that the head of department may approve the reinstatement of an employee who is deemed to be dismissed on good grounds shown. That is reflected in this slide. And then at clause 12, it deals with other remunerative work by employees. This is also a clause that deals with the vesting of powers with the HOD, and gives the HOD may now approve other remunerative work by employees in the public service. That amendment is reflected in this slide. Then on to clause 13. It deals with unauthorized remuneration. It proposes a amendment to Section 31. These were just technical amendments made to correctly reference the commission, that is the Public Service Commission, and the Constitution in Section 30. Those amendments are reflected in this slide. And then moving on to clause 14, it deals with the direction to perform other functions or to act in another post. And it proposes an amendment to Section 32, subsection 1 and 2. So the purpose of this amendment was to clarify the provisions that are already in the Principal Act. So it amends Section 32 to provide for reassignments. Reassignments are also referred to as internal secondments in public service. It deals with where the EA has the power or appoints an employee to perform other functions that are not ordinarily assigned to them. And reassignments are only permitted within the department itself. And the power to the executive authority for that portfolio in respect of a head of department. And the power is given to the head of department in respect of employees to deal with reassignments. And then regarding acting appointments, these are permitted only within the department. And the employee occupying the post may appoint a person to act unless otherwise determined by the head of department. And then in the case of a vacant head of department post, the relevant executive authority responsible for that portfolio can, after consultation with the president or the premier, make an acting appointment. And then in the case of a vacant post, the head of department may appoint an employee to act in a post. That is indicated in this slide. That subsection A indicated in red, that is one of the amendments that were affected in the D list because it was erroneously omitted during the printing of the B list at the time. These are also the amendments reflected to deal with the acting appointments. Then at clause 15, it deals with the grievance of employees, and it proposes an amendment to Section 35(5) of the Principal Act. So Section 35 currently provides that the Public Service Commission shall determine the grievance procedure for the internal processes while it is being addressed within the department, and the external process when it is referred to the PSA if the department fails to deal with it satisfactorily. So in the public service, there are two different, there are two grievance procedures. So the one is the internal procedure within the department where an employee lodges a grievance, and the grievance is then dealt with by the department to resolve that grievance. However, if the grievant is not happy or with the outcome of the grievance, then they may approach the Public Service Commission, and then the Public Service Commission will then deal with that grievance procedure in terms of their grievance rules and procedures. So what the PSC said is that they should not be involved in the internal processes of the department, and it therefore, which is part of the collective bargaining processes that emanates from collective bargaining processes, and that the department should continue to deal with the internal grievance procedures, and the Public Service Commission will deal with the external grievance procedures going forward. Then this is the amendments reflected in the slide. Then this is clause 16, which I referred to earlier. This is the only amendment, a major amendment relating to the limitation of political rights. It's a new provision, and it proposes a new section 36A to the Public Service Act to prohibit heads of department and employees reporting directly to a head of department from holding office of authority or in a political party, and political office was then defined. I'm not going to repeat that this has been expanded, the definition now on the D list that has been approved for submission to the National Assembly. This purpose of this prohibition is to manage conflicts of interest between political parties and administration. Constitutionally, this provision is justified to the extent that it applies to heads of department and employees reporting directly to a head of department. So this provision arises from and is aligned to the Local Government Municipal Systems Act, which has a similar provision. And the department then aligned this definition and this provision to what is already in the Municipal Systems Act. But at some stage, what happened was that the Municipal Systems Act initially indicated that this prohibition should be applicable to all employees at the municipal level. And the Constitutional Court recently confirmed the decision of the Labour Appeal Court that it was unconstitutional and it would be an overreach, an infringement of Section 19 of the Constitution, which deals with political rights. And then following that Constitutional Court decision, in the matter of Democratic Alliance versus the African National Congress and others, the definition was then accordingly aligned to what was indicated in the Constitutional Court. So we are only looking at targeting the top tiers, echelons of the political party. That is the new provision in the clause. It says that a head of department or an employee directly reporting to the head of department may not hold political office in a political party, whether in a permanent, temporary, or acting capacity. A person who has been appointed as a head of department or as an employee who directly reports to the head of department before subsection 1 takes effect must comply with subsection 1 within 1 year of the commencement of subsection 1. And except for the limitation of a head of department of an employee directly reporting to the head of department to hold political office as contemplated in subsection 2, subsection 1 may not be construed as prohibiting a head of department or an employee directly reporting to the head of department from exercising the other political rights as contemplated in Section 19 of the Constitution. So we have appropriately, the bill appropriately addresses and protects the constitutional right of people or citizens to engage in political rights. Clause 17 deals with the remuneration of employees and proposes an amendment to Section 37, subsection 2, and this is one of the provisions where we are vesting the powers in the HOD. That is reflected in this slide. Then at Clause 18, dealing with wrongly granted remuneration, it proposes an amendment to Section 38, subsection 1A of the Principal Act. The provision in the Act was declared unconstitutional by the Constitutional Court. It was in the matter of Public Servants Association on behalf of Hobogu versus the head of Department of Health, Gauteng, and others. The provision was declared unconstitutional by the Constitutional Court, and it seeks to align with the provisions contained in the Basic Conditions of Employment Act, and it puts mechanisms in place to ensure that the rights of employees are not undermined. So basically, in the current provision in the Public Service Act, it allows the accounting officer to make any amount of deduction from the employee's salary to recover the overpaid amount. And following the Constitutional Court decision in the case that I've mentioned, the overpaid salaries can only now be recovered with the consent of the employee. This was one of the changes that was effected at the National Assembly to the bill. It added changes to align with the Basic Conditions of Employment Act, and it put in place conditions that must be fulfilled when determining the amount to be deducted. So an employee and accounting officer must then agree in writing then on the amount of the overpayment, the reasonable period for the repayment of the amount of overpayment, and as well as the amount to be deducted, taking into consideration the employee's income and current financial obligations. So the bill now makes provision for overpaid salaries to be recovered with the written consent of the employee. And where no consent is provided, the overpayment may be recovered by way of legal proceedings. And then in the event that the employee is employed in another department, a provision is also made for the debt to be recovered by the head of department of the new department. And the recovery of overpayments from persons no longer in the employ of the state, it will require legal proceedings or by deduction against any monies owed by the state. And as I've indicated, this was one of the amendments by the National Assembly to include the parameters aligned to the Basic Conditions of Employment Act, to which deductions must conform. And that is indicated in the ensuing slides. And then the last clause 19 brings about a proposed amendment to section 42A subsection 3 that deals with delegations. It seeks to amend the section 42A to clarify the interpretational challenges in section 42A subsection 3A of the PSA, insofar as it relates to the president's power to delegate matters relating to the appointment and career incidents of heads of department. And this section is proposed to be amended to replace references to deputy president and minister with a member of cabinet. So the interpretational challenge arose from the reference to minister, because in the Principal Act, minister means the Minister for Public Service and Administration, and not an executive authority reflecting other ministers. So it was proposed to replace or substitute it with the reference a member of cabinet, which refers to an executive authority. And that is reflected in the last slide. Thank you very much, Chair. Can I stop sharing?
Yes, thank you very much. You can stop sharing. Thank you very much for that presentation. That was pretty clear. Members, as you can see, there's, I want to say, almost 100 pages, it feels like to me, in the presentation, but it is quite a substantial presentation on the bill, which deals with all of the changes, those that are technical in nature, and the whole process. I will open the floor now for questions from members. I think it is pretty clear where we stand. And the only question I really have is it is my understanding from what you've explained that it seems unlikely that this bill will come back to the NA for any changes, that it will probably go to the president for sanction after this. That would be my only question. If you can just provide absolute clarity on that, which means that we will not deal with this bill anymore in the National Assembly. That would be my only query. But members, I open the floor for other questions or comments. Okay, I see no hands. Perhaps you can just answer my question for the moment.
Thank you, Chair. So regarding the Public Service Amendment Bill. This will still be referred to the National Assembly for deliberation because it contains an amendment to the definition which expands on the definition of political office. So according to the parliamentary legal advisors, this will then now, following the ATC, it will then be referred to the National Assembly. Unlike the Palmer bill, that will go for assent to the president because it was just a spelling mistake. One spelling mistake, yes. So it will come definitely to the National Assembly.
Okay, and please bear in mind that both myself and all of the members are new in this committee, and we were not part of the sixth Parliament when it came to committee. So my question is, does it only then come back to the National Assembly, or would I be correct in assuming that it actually first comes back to our committee to look at that broadened or expanded definition of political office, that specific change, and then it goes to the NA?
Yes. So it will first come to the committee because as the ATC indicates, it's part of the committee reports. Yes. So it comes first to the committee and then it will proceed to the National Assembly.
And the committee can then only really consider that specific change. Nothing else in the bill is up for debate or change.
No, because my understanding is that it is, remember already when it was at the National Assembly process, when it first was introduced and it came to the Portfolio Committee, then already several changes had already taken place and amendments. Yeah, okay. So then at this stage, it will only, following the NCOP process, it is the only amendments that will now be addressed at the committee.
No problem. Honorable Khaleesi, I see your hand. Please proceed.
Thank you very much, Chairperson. Good morning to you and the colleagues. I just wanted clarity, Chair, on where the bill deals with appointments. So I just wanted then to maybe find out how does it, is there a way on how the bill like explicitly prevents this, because we've got a recurring problem of cadre deployment where, the politically connected people, yet incompetent individuals are appointed to these key administrative positions, which ultimately is exactly what undermines service delivery. So I just wanted to know, are there any specific measures? I don't know if I missed that, or how does this bill ensures that, that is done away with? Thank you, Chair.
Thank you, Honourable Member. I think that's an excellent question. So it's a question about if this bill improves the ability for us to move towards a more professional and a more merit-based public service. I think it's a very good question. Please proceed with the answer.
Thank you, Chair, and thank you for your question, Honourable Member. So I think if I can start, when the NDP made suggestions regarding the devolution or the stabilization of the political administrative interface, it also had in mind that we should do so also to maintain or to enhance, the professionalization of the public service because of the uneven performance that were identified in the three spheres of government. And following the National Development Plan, and at that time when the bill was still at its policy development process, the professionalization framework that was approved by Cabinet in October of 2022, that professionalization framework, it's a national framework, it actually referred to how are we going to professionalize the public service to make it to warrant appointments in the public service that are based on meritocracy as opposed to allegiance or to a particular political party. So one of the things that the department has already issued is, and to give effect to the professionalization framework, because it has 5 pillars, the professionalization framework, and one of them deals with appointments and recruitment and selection of employees in the public service, and that directly also aligns with strengthening the public service and appointing people based on meritocracy. So what the department has already issued and to give effect to that professionalization framework is that the department has issued a directive. So a directive is a legal instrument that is issued in terms of the Public Service Act, in terms of Section 3(2), and it is issued to give effect and to elucidate on a regulation. So as you know, the public service regulations are issued in terms of the Public Service Act, and from regulations 67 onwards, they deal with the selection and recruitment in the public service and the process to be followed. So this directive that was issued last year, February, it gives and elucidates how the department or public service must now give effect to ensuring that the right people for the right job are appointed based on experience, qualifications, inherent requirements. So there have already been strides in that regard. There are also going to be other volumes. This is volume 1 of the directive. Other volumes to the directive will also ensue. That is to strengthen and give effect to the bill once it is enacted, to put other measures in place to, for instance, regulate, appointments of HODs, which has been a point of contention. So definitely regulations will be strengthened in that process when regulations are being drafted. Thank you. I hope that has answered your question.
I see Honorable Kalisia's hand is raised. I'm not sure if it's a legacy hand. Honorable Kalicia, would you still have another follow-up question?
Yes, maybe a last one on this one, Chairperson. I think having dealt with, I don't know if it's this committee or the communications committee, but maybe it happened with the entities we dealt with as well as we were dealing with the annual reports. So you find out that there are people within the departments that are authorizing, payments. And then now you've got public servants that are found to have received, certain benefits. And we always call for accountability and consequences. But you find out that also when they report, they say yes, or maybe when they justifying their Auditor General's opinion. And they say, no, there was an internal issue, a tender that was given to an internal person. They didn't declare or disclose. And you find out that other people benefit, from the monies that they're not supposed to. So I wanted to find out if maybe this bill mandates any criminal prosecutions, because then now, how do you hold people accountable without consequences? So does the bill have a way of holding them personally, and financially liable to ensure that the taxpayers' money is returned, or it really is silent on those issues? Because you find out that it is difficult to recover the monies that are paid to these people or we just told that so and so, but there are no consequences to the people who do these wrongdoings. I just wanted clarity on that, Chairperson. Thanks.
Thank you very much. I see no other hands, so if we could perhaps just have a feedback on that, I think it's a good comment.
Thank you, Chair. So that question, so I think in terms of the first point is that the Public Service Act does not propose any amendments to provisions relating to discipline and, failure to comply with the Act. That is already standing provisions in the Principal Act, that's Section 16A and Section 16B, which deal with discipline, and Section 16A deals with failure to comply with the Act. So to give effect to that, we also have, in terms of the public service regulations, Chapter 2, which deals with the Code of Conduct. So in the Code of Conduct, and we just want to check to that quickly in my book here. It deals with different aspects of conduct of employees in the public service. And Chapter 2 deals with financial, amongst others, the Code of Conduct, the financial disclosures. It deals with anti-corruption and ethics management, and that's where your question then comes in. So the public service regulations already make reference to the anti-corruption measures that are where employees will then be held accountable should they then transgress, for instance, the Public Finance Management Act when it relates to, failure to comply with procurement legislation. Then also what is important to note, in the Public Administration Management Act, we also have, and as you will see in the next presentation, dealing with the conduct, conducting business with an organ of state. There have been proposed amendments to that, as well as, when one seeks employment, that's a new provision where you seek employment with a service provider, and an employee was part of that procurement process, in any part of the procurement process, and that employee then leaves the department and goes to work for that service provider. The amendments in the PAMA bill, which will follow shortly, provides that it will be a criminal offense if you join that service provider's employment within a period of 1 year. So there are measures in the bill, and that are addressed also then in the PAMA, in addition to the Public Service Act and the regulations. So, and in that instance, in the PAMA, it makes provision that it is also a criminal offense. Thank you.
Thank you very much. I see Honorable Kaba's hand. Honorable Kaba, please proceed.
Thank you very much, Chairperson. Chair, let me welcome the presentation. It is well and good, but Chairperson, let me concur with Honorable Tsilisha in the issue of mismanaging the money of the taxpayers. Chair, it won't be good things to the taxpayers to hear that the person that was stealing the money or was using the money wrongly, he's just being dismissed and disciplined. Nothing happened to her or him. It must be something. It must be a consequence management. It must be something to deal with that person, like maybe to recoup the money that the person, because that person is working and is getting paid every month. The money must be recouped to go back to the way it's supposed to be. Or that person must be put in jail. Must be a harsh example, a harsh discipline to the person that is misusing people's money. And so now my question is that, what is the other mechanism that the department can use to that person, except to discipline him or her living like that? I thank you, Chair.
Thank you very much for that question. If I could just get back to the department for an answer, thank you.
Thank you, Chair. So if I understood the question correctly, so in terms of, as I've indicated, in terms of the Public Service Act, it does provide for consequence management, and that is addressed in Section 16B of the Public Service Act. And in terms of the PSCBC resolutions regarding the process to be followed in the dealing with discipline cases, they will obviously have to be procedural fairness and there must be procedural fairness in the matter. However, that is one process that is followed within the departments for consequence management. Then the department can pronounce on different types of sanctions, whether it's written warnings, verbal warnings, final written warning, dismissal, etc. On the other hand, nothing stops the department from then also reporting a criminal case, like theft of public funds and things like that. For reporting the case as a criminal case to the department, to the criminal justice system, open up a criminal case, and that is a separate procedure where the investigating officers in the police will then investigate the matter to determine whether there is a case to be prosecuted. So that is a separate process that will be used. It can happen simultaneously. However, the department process will run separately. It will adhere to its time limits, and the criminal process will run separately. If the department decides, for instance, that the sanction for this employee is dismissal, then he will be dismissed. And if that person is in the department, so in the event that the disciplinary process is still carrying on in the department and the criminal case finds that the employee is guilty of theft, then automatically the person is deemed dismissed in the department based on the fact that now he has a criminal conviction. So that is the other avenue that is followed to deal with employees who are alleged to have committed theft or corruption. Thank you.
Thank you very much. Honorable Khaleesi, I see your hand.
Maybe a clarity, Chair. Thanks. I hear when the department is telling us that there is a prohibition of joining a certain company or after a year for these employees because they leave the departments and go work for these companies. I understand that, but I think there is and I don't understand why there is a provision for executive authority to approve outside work. I'm then wondering, and I'm then wondering, Chair, that shouldn't there be a total prohibition on any other payable work to just eliminate, the potential corruption and conflict of interest. So I was just wondering that, Chairperson, because I'm just wondering that, Chair.
No, it's a fair question, Honorable Khaleesi, and I think it would actually make life probably just more simpler to just put a ban on all civil servants to not do business with the state in any form. Although, if I recall in one of our meetings, and I'm speaking under correction, I think the example was used of teachers. Sometimes teachers can use their spare capacity to help with marking of exams and exam papers and assignments for other schools or institutions who need the service, and thereby earn some extra money for themselves by providing a service to the state, which they are obviously educated and trained to do. And if I remember correctly from that presentation, that was used as an example of there is some skills within the civil service which could be offered to other government departments and give the civil servant an opportunity to earn some extra money if it is all done transparently and it is all signed off in the correct manner. But I will give over to the department to answer your question. That's just what came to mind now. Although I must admit and agree with you that it would probably just be easier to put in a ban and just say nobody is allowed to work with government. But I'll gladly hear the comments from the department.
And maybe to add, Chair, and I think this we were having in the committee, maybe not formally, and we were having this, and we asked ourselves this question: that should a Deputy Director General, for instance, a DDG, be allowed to serve in the executive committee of a political party while overseeing the implementation of that party's policies? Right? Because then now you have these political party membership structures. Does this limitation extend to this membership in political party structures?
Yeah, I agree with you, and that, I think it's an interesting opinion on the matter. Perhaps the department can shed some light for us on the matter.
Chair, thank you. My colleague, Dr. Foromo, will assist in answering the question. Thank you.
Thank you. Please proceed. You're not audible. It seems, yeah, not audible. We can't hear. We're going to have to give back to you to shed some light, please.
Thank you, Chair. I did WhatsApp him and see if he can. I don't know if his audio settings are not correct. But so regarding other remunerative work, and Dr. Foromo is the lead on that. But so in order to deal with other remunerative work, the department has issued a directive, as I've indicated earlier. The directive gives effect to the section in the Public Service Act that deals with other remunerative work. And in that directive, it sets out the procedure to apply for other remunerative work. And that process is not, it's an application process. So what other remunerative work refers to is, it refers to any business carried out or services rendered for gain or personal benefit by an employee outside of his or her employment for which he or she receives remuneration. So this directive sets out the application procedure. An application is a pro forma document that needs to be populated by the applicant or the employee, and then the applicant then submits the application to his supervisor to recommend that he or she can perform this other remunerative work. And the applicant then also then submits this application to the ethics officer in the department for processing, and analyzes if there are any possible conflicts of interest for the other remunerative work and the functions that he or she is already performing in the department. So the ethics officer then submits the application form to the delegated official for the decision to approve and disapprove. So that would, in this case, if regarding the proposed amendments to the bill, that would be the HOD. Then the delegated official then will make the decision, and then to approve or not to approve, and then they send the application back to the ethics office within the department. And then the ethics office then communicates this the outcome of the application to the applicant. So it's a rigorous process, and they must give an answer within, it must be processed within 30 days. They must answer to that application within 30 days. So it is a rigorous process to determine whether or not there is a conflict of interest with the other remunerative work and the work, the performance of functions by the applicant or the employee. So one of the mechanisms is to monitor the performance of the employee. So when, for instance, the employee's performance is not, satisfactory by any measure, it can be deduced that, maybe the other remunerative work is now impacting on his or her work. So these things are taken into consideration. They are, reviewed throughout the process, because permission is granted for, I think, a period of 1 year. And you need to reapply when it expires. So there is proper, accountability mechanisms in place to ensure that the, employees does not, his other remuneration does not impact on his work. So, and, the risk and ethics management unit, for instance, in the department, hereby the department, they do comply with the directive. We haven't received any sort of, interpretational issues or anything regarding other remunerative work. So I think it's properly monitored in the department, but there's no blanket prohibition on not allowing somebody to not do other remunerative work. And so there's checks and balances in place to make sure it is not abused and the employee is monitored. Thank you.
Yes, thank you very much. That was my understanding of the current situation as well. I think it is. It's now almost 11:30. I think it's time that we move on to the presentation.
Okay. My apologies. In my gadget, I don't see where I can raise my hand. Unfortunately, good morning to you, Chair, honorable members, and senior administration of our government. Chair, I just want to first welcome the presentation, Chair, as much as I know that we won't have another chance to do any additions on it. But I would like to ask whether the things we are raising cannot be included in the regulations when the minister is doing regulations on the implementation of the bill. Because in my view, as much as it is being clarified, the issue of the application for for other jobs. It's a challenge to monitor that. And also, Chair, I believe in the issue of employment, especially the senior administration, to avoid this issue where all of us, we cry about the issue of cadre deployment, because I believe I might be now defending the ruling party or the African National Congress, my party. We all have interest as politicians on who must be appointed to implement the policy, whether you are in government or you are in opposition benches. That's my interest. And also, I believe not all managers are members of political parties, but they vote for their preferred political parties. That's basically an interest. What I believe can be echo to whatever is happening is a process which is very transparent, as it is done with all other either section for section 9, what was presented for IEC yesterday, where the processes and interviewing processes are very transparent for all citizens to see. Because you may take someone whom we believe that is not a politician, but when he's in an office, he has to implement the policies which are from a political organization. Of course, we must have a process which is transparent. In other cases, someone might be belonging to a political party, but can actually do the work correctly. But since he's known that he's an active member in a political party, is being ignored to be afforded an opportunity to implement the scales. I believe if there's in the regulations, at least we demand or we request that there must be a requirement where there's transparency in the appointment. Once you acknowledge that the panel is done by the president in case of teachers and other things and premiers, in case of HODs, but there must be a process where communities are observing the process, because what we know generally, we want to build the trust between our communities and our government. Lastly, Chair, in the issue of business interests, I'll make an example which can be seen as something which we might not care about. If you go to police, most of wives of police officers are unemployed. Those wives are having licenses for taverns. And those police officers are having a mandate to monitor the operations of taverns. Some taverns are licensed, some are illegal, and we expect them to do the work. There's a lot which we need to look at, because if you talk, he will say, right, I'm employed as a police officer, but my wife is unemployed. My wife is having a right to do a business, and unfortunately, sometimes some of them are suppliers, wives are suppliers of some goods to these departments. So there's a broad way. I think an open discussion needs to be done with regard to this topic. Thanks, Chair.
Thank you very much, Honourable Tikana. I think those are fair comments. Unless I misunderstood you, I don't think there's really a question to the department here, but I would like to believe that we will have the opportunity to, as per your request, engage with the minister, who will be ultimately responsible for the writing of the regulations, to discuss with him all of these different issues which have been raised by the members, which I think are the comments from yourselves and the other honourable members are all of equal importance, and demand consideration by the minister. So I think that we must perhaps schedule a session with the minister himself where there is an open forum, and perhaps that would be when we deal with this this legislation when it comes back to us in the National Assembly and comes to the committee. Members, if there are no more other comments, then I think we must proceed to the next presentation on the next piece of legislation. Can I please ask the department to proceed with the next presentation?
Thank you, Chair. I see my Dr. Foromo. I can see him. I don't know if he's able to present. I don't think we can hear him still.
Doctor, if you can try and unmute and just see if we can hear you. At this stage, it's still quiet.
Have unmute. Can you hear me now?
There we go. Welcome.
Okay, I'm using the phone. Am I audible?
Yes, you are now audible. There was some initial feedback. Perhaps you had two devices on at the same time, but now it is perfect.
Okay, I've tried to switch off the laptop and I'm using the phone. Roshita, can you actually load it for me?
I will do so. If you can stop sharing on your side, then I can share for you. Thank you.
Okay. 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 Put it on the slideshow. Okay, thank you. Let's go to the next slide. Okay, the process of this bill, it started in 2014. The bill was actually enacted in 2014, and this process for reviewing it started in 2019. And the reason behind that was the genesis of the bill arises from the national development plans, the changes of the legislations and the policies, and also the objective of the single public administrative initiatives, as well as the professionalization framework and the response plan of the presidents to the report from the Zondo commissions. And the bill seeks to create a public administration that is people-centered, cohesive, synergized, efficient, and effective. And also is to strengthen the existing legislation to ensure that the public service functions and structured in line with the sections 97 of the constitutions. And we also want to professionalize the public administrations in line with the sections 195 of the constitutions. And more and above is to improve the state capacity and the capability, specifically on the human resource skills and also the system and the processes. The next slide. And clause number 1 is actually talk about the definitions. And then it's more outlined in the next slides. Yeah, the new actually definitions was the head of institutions. In this case, it means the National Provisional Department and the government component, and the head of department as defined in Section 1 of the Public Service Act. And also to include the municipality, the head of institutions, in this case it's municipality, whereby the municipal manager will be defined as the head in terms of Sections 1 of the Municipality Act. And we also refer to the Labour Relation Act, the Municipality System Act, and the national government components, which it was not there before. And then also the organ of state. So the organ of state, it means it's a national department or provincial department, or a national government component or provincial government component. As well as the public schools, the municipality, the public entity, and any institutions performing functions in terms of the constitutions or provincial constitutions performing public functions in terms of any legislations mentioned. Now, the new definitions is the organized local government, which means it's an organization recognized in terms of Sections 2(1)(a) of the Organized Local Government Act. And the provincials department, it means the office of the premier listed in column 1 of the schedule, and the provincials department as listed in column 1 of the schedule. Provincial government component, it means a provincial government's component listed in the component, and the public entity means as defined in Section 1 of the PFMA. Municipality entity as defined into the municipal system. These are the definitions which were not there from the Principal Act, and then they are being actually included in the new Act. The next slide. I think this one is, I've already explained it. The amended is on the right-hand side, yes. Now, clause number, it's fine. Clause number 2 is about the transferred. The transfer enabled the mobility of employees across the spheres of governments where human resources deficiency exists or where the operational requirement necessitated. This clause, in short, it's actually talking about that the new bill, it's actually allowing the transfer of an employee from a national government to province, or from a province to municipality, or from a municipality to national or to provinces. So the current act, it did not actually allow that. So this bill, it says we need to look on the transfer of those employees based on the human resource deficiency or in terms of the operational requirement. And then the initial act, actually the transfer, it did not actually include that an employee should be given consent. It was based on the employer amongst the national and the provincial. So it never talked about making a transfer to the municipality. Now, based on the concern raised through the consultations regarding the employees transfer without their consent, the bill only provides the transfer of employees between the public service, as I explained, and then municipality between the different municipality with consent. So the Public Service Act will continue to regulate the transfer between both nationally and provincially. The next slide is actually explained. So the amendment provisions, an employee may only be transferred when there is a reasonable ground to do so. And the employee also, if the employee is suitable, qualified in terms of the act, mentioned act there. And if the employee requests or consent in writing to be transferred, or with the concurrence of the relevant executive authorities of the transferring and the recipient's institution. In other words, the executive authority who is releasing the employees and the one who's receiving, there should be a concurrence that there is a need to do so, especially based on those recent mentions above. The next slide. It continues. If an employee is transferred in terms of Section 1, transfer does not interrupt the employee continuity of employment, and then employee may not upon the transfer suffer any reductions. In short, when there is a transfer and the employee has agreed and both the executive authority has agreed, the benefits of employees should not actually be reduced to the favorables of that employees being transferred. In other words, here there is a guarantee that the remunerations and the condition of service are not going to be changed unless the employee consent to do so. In that case where the employee will consent, it means that it's when the employee is requesting to be transferred. But if it is based on the deficiency and the operational needs, that remunerations and the condition of service will be actually retained. The next slide. It's still clause number 2 for transfer. If an employee is transferred in terms of section 1, the remuneration and the condition of service of the employee upon transfer are as agreed between the executive authority and the transferring one and the respective institution. If an employee is transferred in terms of section 1, and unless the employee consent, I think this is exactly what I just explained, that the conditions and the benefit will actually be retained. The next slide. Then we come to clause number 3. Clause number 3, it's a secondment. So there is a difference between secondment and transfer. So clause 3, it seeks to amend section 6 of the PAMA, requiring that secondment be effected if it is operational justified. So there shall be no any secondment if there is no justifications in terms of this clause. Then the next slide. Now, the amendment from this clause number 3, it says an employee may be secondment in terms of section 1A if the employee possesses the necessary skills, the knowledge for the intended positions at the time of the secondment. B, if the employee requests or consents to be seconded. C, in the absence of consent, after due consideration of any representations by the employee, if the secondment is operationally justified. So secondment, it will be based on these conditions, that we are not going to secondment anybody which is less qualified. You have to have the same qualifications and the NEP skills. And secondment, it is not permanently. The next slide. Then clause number 4, transfer of employees upon transfer or assignment of functions in section 7. So in this case, it is to repeal the current law with the new one. To say clause 4, it's repealed section 7 of the PAMA to avoid duplications, the transfer of functions and the transfer of employee affected by the transfer of functions and legislated across institutions. It is regulations in terms of those acts. Then the provision is made in the repeal clause to retain section 14.4 of the Public Service Act. The next slide. Now, this one is to say clause number 4, it has been repealed based on the current provisions. And the current provisions amendment, this is the one it means then. Clause number 5, conducting business with the state. I think this is the questions that the honorable members, they were having a consent from the Public Service Act about employees doing business with the state. So the current bill, it says provide the terms conducting business with an organ of state as opposed to conducting business with the state. In this case here, every government employees or working in the component, it can be government, like we have got a government's printings. In the provinces, you do have the components like the Limpopo Economic Development Agency or the Gambling Board or even the ISCOM, just to give it an example. So those are the state of organ. So we are saying not all the organ of state is used between this act. So there was not there in the current act, but now we are trying to bring it in so that we can cover all the entity and any other government component that no one will be allowed to do a business with those other people. Currently, somebody who is working in an entity could do the business with the state because they were not involved. Now we are saying, even when you are working in the ISCOM or you are working into the board, you can't come and do business with the state because you fall under the organ of a state. So it's to clarify that an employee who is a director of a company incorporated in terms of the Companies Act is precluded from conducting business with the organ of a state. This would include a state-owned company, a private company, or personal liability company, a public company, and a non-profit company. Clarity that employees appointed ex officio on boards are not construed within the scope of provisions in terms of this Section 8. In other words, we are saying, if an employee, like you are a medical doctor, you want to serve in a GEMS board, in that case, you are not actually excluded, because the reason for you to be allowed to work into the board, there is the minister actually will consider your skills, that your skills are needed the other side. So it cannot be taken as you are doing a business with the state. The next slide. The amendment provision in these sections, employee includes person contemplating sections 12A of the PSA and a person performing similar functions in a municipality. So the current act did not actually include people into the municipality. So this bill, it's going to function both the three spheres of government. It's going to function into the municipality, the provincial government, and the nationally, and it shall be implicated or applied even into the state organ. So a director, it means a director of a company as defined by the Company Act, does not apply to an employee appointed ex officio as a director of a public entity. That was the example that I give with the GEMS, that if you are a board member and then you have got a skills, but you are still working in government, you wouldn't be considered as you are doing a business with the state, but you will be actually, the minister will actually allow you to function in that positions as a board member because of your skills. The next slide. An employee may not, subject to Section 4, conduct business with an organ of a state, be a director of company incorporated with the Company Act, is exactly what I have explained, that when you are in that case, then you will be considered in that way. A contravention of Subsection 2 is an offense, and any person found guilty of, this is clause number 5, still conducting business with the state on Section 8(3). So it says 3, a contravention of subsection 2 is an offense, and any person found guilty of the offense is liable to a fine or imprisonment for a period not exceeding 5 years, or both such fine and imprisonment. Constitutes serious misconduct which may result in the termination of employment by the employer. I think that was my colleague, she was explaining, where the honorable member, they were worried that what do you do when somebody has been contravening, doing the business with the state and nothing happened? It's only limited to the disciplinary processes. So it is an offense. So this bill, it actually say it is an offense if you are fined wanting. And this is the punishment that it will actually apply, that you can go to prison or you get both. The next slide. Then clause number 5, it's still the new clause. It says the minister may prescribe that a certain transitions between an employee and an organ of state, which are remunerative but not for profit, and which are necessary for the functioning of the organ of state, do not constitute conducting business with the organ of state. That is the same example that I give with GEMS, that the minister may approve. And when it gets done, it's not going to be taken as you are doing a business with the state. The next slides. Clause number 6, conduct of employee or a former employee participating in award of work to service provided, Section 8. So in this case, new clause, it says the amendment seeks to address post-employment restrictions for employee who participate in procurement matters. Either you evaluate, adjudicate, and issuing of the tenders. Then the provision is made for the impositions of 12-month cooling period. So this clause, what it says is to say any employee or the one who left, if you are an employee and you find yourself that you were participating with the process of procurement, or supply chain processes. You cannot offer that particular job to a service provider and then you resign today and you go and join that particular company. So now we are saying the previous law, the current one, it was saying you will only have a 12-month period. That once you were involved in the process of supply chain, and then you decided to resign, you can't go and join that particular company. But for you to join that particular company, you must have a 12-month cooling period before you can join. Now, that was the current law, it says. So the new one, it says, because you can just, even if you want to wait for 12 months and you don't do it, there was no any punishment. So the current law, it says, if you decided to ignore our rules to say you can't go and join, and you happen to join, you will be actually convicted. It says the service provider or employee who contravene these provisions are guilty of an offense and on convictions liable to a fine not exceeding 1 million, which amount may be adjusted by the Minister of Justice from time to time. So the provisions remain the same except that the definition were redrafted. So in this case, if you happen to go and join that particular company, you will be actually committing an offense and you will be expected to pay 1 million or you get imprisonment. So this is the new clause that redrafted by the National. It says in this section's 12 months period means a 12 calendar months following the conclusion of the contract with a service provider. And the service provider means a person who provides services or goods to an institution against the remunerations. And then number 2, an employee who, in respect of the award of a contract to a service provider, set the criteria, evaluate or adjudicate, recommend or approved the award, and then participated in any activity contemplated in 1(2)(c), may not, within 12 months period, provide any service to, accept employment with, or accept appointments to a board of that service provider for payment in money or in any kind, or receive any other gratifications from that particular service provider. So this clause is actually trying to tighten the weaknesses that we had in the previous one. The next slide. Then it's continuing to say a service provider may not within 12 months period engage any employee who was actually found participating in that process. And then number 4, subsections 2 and 3 apply irrespective of whether the employment of employee contemplated therein continue or did not continue with the relevant institutions during the 12 months cooling period. Then the executive authority may, in accordance with the prescribed criteria, approve a period shorter than 12 months period contemplated in subsection 2 or 3. So the current act, it was say strictly 12 months, you can't. Now this one, it says the executive authority may consider to shorten the period as contemplated in those above sections 2 and 3. The next clause. Subsection 2 and 3 is still the same one for conducting business with the state, for participating. So subsections 2 and 3 apply with the necessary changes to any extensions of a contract with a service provider. If the remunerations for that extensions together with the remuneration of the original contract and any other extension exceed the amount prescribed by the minister in terms of sections. Any person who contravenes subsection 2 and 3 guilty of offense or any liable to a fine not exceeding 1 million. So in other words, if you have processed the tender which was 500,000 and you decided to leave, if you happen to contravene, you may be fined an amount not exceeding 1 million, more than what you actually issued. The minister responsible for the administration of justice may from time to time, by notice in the Gazette, increases the amount referred to in subsection 7. So it's giving the Minister of Justice may decide to increase the millions to an amount above 1 million. New slides. Clause 7, it's a disclosure of financial interest. For the purpose of these sections, employee includes a person contemplated in sections 12A of the Public Service Act, and any person performing similar function in municipality. Next slide. Next slide. To amend sections 10.2 of the PAMA to provide that department must, within the available budget. No, just go back to clause number 7. I think this one is a new clause which was saying all the employees in government, even in municipality, they will be expected to disclose their financial interest. And then the previous clause, it was only limiting to senior managers. But the current one, it says even those one who are working in the supply chain and other lower level, they should actually disclose. And in this case here now, it's forcing even the people working in the municipality, if they were not disclosing, this act, this bill, it forces any employee, whether you're working in municipality or you're working in the state of Oregon or you're working there, you will be expected to disclose your financial interest. And then it goes with the dates. So the Public Service Act, it gives the dates when SMS members, they're supposed to disclose, when the lower level is supposed to disclose. So upon approval of this bill, probably there will be a regulation whereby it will actually give guidance even to the municipalities. The next slide. Clause number 8 is about capacity development by the institutions. To amend 10.2 of the PAMA to provide the department must, within their available budgets, provide for a compulsory training that is directed by the minister to address the development needs of categories of employees. In this case here, we are saying the executive authority, based on the need of the department, there shall be a compulsory training that it should be given to all government employees. So it will be a must. It is not if I need, if I want, but if the department see to feel that you need to be sent for financial training because you're working in finance unit or supply chain, you shall go. The next slide. Then the amendment provision is, in addition to the education and training budget requirements in terms of the Skill Development Act or provisions for the training levy in terms of the Skills Act, and institutions, must make an appropriate provision in its budget for the compulsory education and training contemplated in sections 3.1b, and within its available resources for the education and training of its employees. We are trying to secure the training budget here. To say you can't send people because there's no budget. Therefore, you are forced, the accounting office is forced to make sure that there will be a budget because there are acts that actually make provisions for those training and education skills in the government. The next slide. Now, clause 9 is about the National School of Government, the NSG, is to amend section 11 of the PAMA to create the NSG as a national department, as it is currently, as opposed to it being created as a higher education institution, while still empowering the national government, the National Schools of Government to provide education and training to employees in all spheres of governments, including municipality. The current act, it did not allow the NSG to provide training to municipality. So this one is actually says the NSG will be able to extend their training even to the municipality. And then the NSG will provide education and training to public entities upon request. It means now it will also go to those state of Oregon where it was not provided. So now if they want to be provided some training, the NSG will have mandate to do so. Also, the provision is made for the NSG to provide programs and courses and to issue qualification, part of qualification or certificate subject to the NQF Act. So currently the NSG was not providing a qualifications, but here it says this act is giving a provisions to the NSG that they can be able to give a qualification or part of qualification and certificate subject that the National Qualification Framework Act is implemented. During the portfolio committee, the NSG requested the committee to include a specific provisions to enable NSG to conduct assessment in respect of education and training. So this was not there, and then the NSG executive, they requested that may they be given permissions to conduct an assessment in respect to education and training. In other words, they don't want just to offer a training if it's not going to add any value. And then in this clause, actually, if you see the highlighted one, is exactly what I just explained, that they request to do an assessment and then be able to provide the qualifications. But the process of giving the qualifications may subject to award qualification or part of qualification on the successful completion of education and training program, or cause such qualification or part or be awarded. So currently they were not able to do it, but they are requesting that going forward, can they be looking to provide the qualifications? The next slide. Clause 10 is a directive by the minister relating to education section to repeal section 12 of the PAMA following the amendment in clause 9. It's just, we are actually amending the previous clause and then try to repeal the previous section 12. The next slide. That section, clause 10, is repealed. The next slide. Clause 11, compulsory education requirement for employment, section 13, is to amend section 13(1) of the PAMA to remove the unnecessary burden placed on cabinet in the determinations of a prerequisite of mandatory education and training. So I think this clause 11, it's in line with the previous act to say there will be a compulsory training and requirements. So currently, if anyone want to do that, there was the NSG, they will have to go to cabinet and ask a CAB member. And instead of looking for the CAB member and the determination, can we make it a regulation? So that is clause 11 that it says so. Next slide. Now, clause 11 again, it says amending provision. The minister may direct that the successful completion of specified education, training, an examination or test is a prerequisite for a specified appointment or transfer, a compulsory in order to meet the development needs of the category of employees. 2, the minister must consult organized local government and obtain the concurrence with the minister responsible for local government in respect of a directive to be applicable to municipality. If this compulsory training is going to happen in municipality, the minister of DPSA cannot just take that decision alone. Will need actually to consider the relevant minister looking to finalize the directive so that it may be applicable to municipality if there is a need. The next slide. Clause number 12, minimum norms and standard. Section 12 is repeal. To repeal section 16(2) of the PAMA, which creates a requirement that when the NPSA issue norms and standards in respect of the promotions of values and principles contemplated in section 95 of the Constitution, all executive authorities must consent. This is impractical. So this repeal will allow the minister to issue norms and standards in respect of the promotions of values and principles through regulations following the process contemplated in section 18 of the PAMA. The next slide. Now, the amendment of that clause of section 12 is the minister may prescribe minimum norms and standards regarding the promotions of values and principles referred to in section 1951 of the Constitution, capacity development and training, information and communication technology in the public administration, integrity, ethics and discipline. E, the disclosure of financial interest. F, measure to improve the effectiveness and efficiency of institutions. G, disclosure of information relating to pending disciplinary action and conducting disciplinary procedure where the employee was found guilty, and any other matter necessary to give effect to the administration. The current law, it was only applicable with these norms and standards only in national and provincial. Now it's just an extension that it should be actually be applicable even to the municipality. The next slide. Clause 13, Office of the Standard and Compliance. To amend Section 17.7 of the PAMA to remove reference to and its members. And Section 17.7 of the PAMA require the minister responsible for the public safety administration to prescribe the powers of the office and its members. The PAMA does not provide for functions of individual members. It is proposed that it is not necessary for powers of members to be prescribed, hence the proposed deletions of this reference. So the current law, it was given powers even to the members, to the officials who are working in the office of the standard. Now we are saying this power should not be given to individual. It should be given to the office. If you work there, then there will be power to enforce the norms and standard through the Office of the Standard and Compliance. Next slide. The amendment provides the minister must prescribe the powers of the office, including those who are necessary to achieve the objective of the office. The next slide. The new provisions, clause number 14, removal of disparities in public administration, section 17A. The proposed section 17A seeks to address the removal of unjustified disparities across the public administrations, including public entities. 17A is limited to employees who do not fall within the scope of the binding council. Section 17A seeks to address unjustifiable disparities by providing a process for the minister to, after consultations with the relevant minister responsible, prescribe norms and standards to establish the upper limit of the remunerations and condition of service of employees who do not fall within the scope of the relevant bargaining council, and stepped to remove unjustifiable disparities, same among employees in or across the institutions and public entities. Reflections of the changes. 17A1A was initially intended to cover all employees. However, the discussion is in the portfolio committee where that condition of service of employee within bargaining units must be dealt with in terms of the bargaining arrangement. The provisions was amended accordingly. Let's look the next one. Then the new clause as revised in the National Assembly to exclude employees who fall within the scope of bargaining unit. Removal of disparity in the public administration. Now, 17A, in order to remove unjustifiable disparities in relations to remuneration and condition of service of employees who do not fall within the scope of relevant bargaining council, the minister may, subject to applicable labor legislations and legislative governments, the employment of females in public administrations, and after consultation with the relevant minister, prescribed norm standard to establish the upper limit of remunerations and condition of service. In short, this clause, it says, we have got disparities in terms of the remunerations. So the minister, in consultation with that particular minister of that sector, may determine the amount. So in order to reverse it, sometimes here we found that the CEO of ISCOM is earned more than the president of the country. But all this money, they get determined from Treasury. So what we are trying to say here is the removal of all those disparities in the public administration. So when it will happen in terms of those particular disparities, any minister to that particular sector and the minister of MPSA will have a consultations to determine the amount that it can be paid so that we should not have disparities. We should not have this movement. Remember this bill is to say we should be able to transfer employees based on their skills where they are needed. So now if we have got the same remunerations, it won't be difficult. But in this case, we are saying we should not find the municipality manager earning more than the DG of the president. So we need to actually reverse those remunerations so that it can be equally and justifiable. The next slide. Determination of condition of service with financial implication is just now a summary of what I was saying. Section 17B provides the coordinations of mandating processes of collective bargaining in the public administration, including public entities. These provisions do not seek to interfere with the existing collective bargaining structures and processes and must be separated from bargaining outcome. It seeks to strengthen the way the state coordinates itself and manage its finances to ensure that a certain sector are not advantaged over the other. That's what I was explaining. The National Provincial Department employers may only enter into a collective agreement with financial implications with a mandate from the Committee of Ministers as defined, that the COM is the Committee of Ministers defined as the COM. And local governments and public entities, the MPSA, then the Minister of Finance must be consulted. Provides for an intergovernmental forum to be established by the Committee of Ministers, including SALGA, premiers, deputy ministers, to ensure that such parties are consulted in these processes. Any determination on condition of service must take into account affordability and any other factors prescribed by the minister in consultations with the Minister of Finance. Condition of service is defined to include annual salary adjustment, salary scales, levels, performance bonuses, pay incentive, pension benefits, and other such things. So, reflection of change. The provision initially proposed that the concurrence of Committee of Ministers was required for any collective agreement. So the Portfolio Committee revised the bill to require the concurrence for the public service, retaining the stated core, requiring consultations with the MPS and the Minister of Finance for other sectors. In short, what this clause it says, any benefits, they are negotiated at a collective bargaining. So now we are saying, if there is any financial implications, the minister responsible for the local governments, when they want to enter into financial bargaining, they should not do it alone. They need actually to make consultations with the Ministry of Finance so that we don't have these disparities. That is what it means, this short, to say any determination of condition of service with financial implication. No, like a sector minister should not take that responsibility alone. A minister of police cannot decide to increase the salary of the police without considering or consulting with the Minister of Finance if there is budget to do so. So this is what this clause number 14 tried to correct, that there must be a consultation and the Committee of Ministers, which it will include the SALGA, the premiers, the deputy minister, should actually be consulted before or during this process, before any minister can actually decide it, that I want, in my sector, I want to increase my salary, or I want to give any other incentives. The next slides. New clauses revising the National Assemblies to exclude Committee of Ministers approval from LG and PE provincials. A determination of conditions of service with financial implication. In this section, accounting authority in relations to this is just the definitions that is actually being defined. Who is the executive authority? What is a condition of service and accounting officer? The next slide. New clause. Subject to the Labor Relations Act, the laws governing the employment of employees and any collective agreement. No executive authority in the public service may enter into a collective agreement in respect of condition of service with financial implications or determine them for their employees without a mandate from the Committee of Ministers. No executive authority, municipality, accounting authority, accounting officer in respect of the public entity may enter into any collective agreement in respect of condition of service with financial implications or determine them for that public entity employees without first consulting with the minister and the Minister of Finance. The minister responsible for local government and organized local government in respect of municipality may not enter into any collective agreement in respect of condition of service with financial implications or determine them for municipality employees without first consulting with the minister and the Minister of Finance. The Committee of Ministers must establish an intergovernmental forum in terms of Section 9(1) of the Intergovernmental Relations Framework Act, including premiers, deputy ministers, and any other member of the committee may determine to consult for the purpose of subsections 3. The Committee of Ministers, in determining the mandate contemplated in Sections 3 and any other employer in the public administration prior to concluding a collective agreement or determine condition of service for their employees, must take into account affordability and any other factor prescribed by the minister and consultations with the Minister of Finance. It's just a summary of what I have just said. The next slide. Clause number 15, regulations. Amendment clause. To amend sections 18(2) of the PAMA to provide for the making of regulations by the minister for the MPSA, insofar as it relates to municipalities, in consultation with the minister responsible for local government and the Minister of Finance. After consultations with the with organized local government, this is to align with the process currently adopted by the Local Government Municipality Act regarding the issuance of regulations. So these any regulations that it will happen there downwards, there must be a consultations with other ministers. The next slide. Now, the amendment provisions of clause number 15 in terms of the regulation says the minister must make regulation insofar as they apply to municipalities in consultations with the minister responsible for local government and minister responsible for finance after consultations with the organized government, local government. 2A, capital, any regulations made in terms of section 17A may only be made after consultation with the minister responsible for the public entity. The next, substitutions of the schedule to PAMA. The amendment provisions, the repeal of the Transfer of Staff to Municipality Act, the repeal of Section 4 and 15 of the Public Service Act, Section 14 of the Public Service Act dealing with the transfer in public service is reenacted. The next slides. Now, clause number 16 for substitution of the schedules as from above slides. 2A, capital and small one, subject to the Labor Relations Act and any other collective agreement. The determination of any condition of service for employees in general or particular categories in terms of this act, and educators or members of the service in general for a particular category in terms of the law governing their employment shall be made with the concurrence of the Committee of Ministers referred to in section 17B2. So this is to include other employers like the teachers who are getting employed by the Educational Act and those who are working into the security cluster, the state agency. This is the consultation that is actually expected. For the purpose of paragraph A, condition of service include annual salary adjustment, salary scale levels, performance bonuses, incentive, pensions, and any other benefits of similar nature. So it's just to strengthen that anything to do with the benefits, no sector minister can make that decision alone without consulting the relevant Committee of Ministers. Next slide. Clause 17, short title and commencement. The clause reflects the short title as the Public Administration Management Act 2023 and comes into effect the date determined the president. In other words, this bill we are saying, once it gets signed by the president, it shall be called a Public Administration Management Act 2023. The next slide. I thank you, Chairperson. Back to you.
Thank you very much, Professor. I think that was a thorough presentation, and you did highlight, I would say, some of the most important aspects of the bill. Members, any deliberations now, any questions about this bill? It is my understanding that this specific bill will not come to the National Assembly. It will, in all likelihood, pass straight to the presidents to be ascended. But I open the floor if there is any comments or questions on the bill. Right. Does not seem like there is any questions. Let me just give one. Let's just give 30 seconds more. I see there is a hand raised. I don't recognize the member. I'm not sure whose phone that is. It says Khosi's iPhone. Please identify yourself.
Khosi Letlape.
Oh, hello, Honorable Letlape. Welcome. You are most welcome. Please proceed.
I just wanted clarity on one thing. There was a comment about the amounts that you can be fined if you are an employee that joins an entity within a year of concluding business with that entity. Did I understand correctly that amount can be varied by the relevant minister?
Mm-hmm.
The amount of up to $1 million. Can it be varied by the minister, or should it be predetermined? That's the question that I'm asking, Chair. And thank you for the presentation.
Can I respond, Chair?
Yes, please. Thank you.
Okay, thanks, Honorable Letlape. No, the 1 million, it shall be remained. But the only person who can change it will be the Minister of Justice as time goes on. But the current one, we're proposing that whoever who will contravene will be fined an amount not more than $1 million.
Okay. Thanks for the clarity.
Yeah.
Thank you very much. Honorable Telise, please proceed.
Thank you very much, Chairperson. I think I've got one or two. I just wanted clarity, Chair, in terms of anti-corruption and ethics. So I just wanted to find out if the minister can, because so we've got the bill prohibits doing business with the states, right? And we've got a situation now that exists, and I think my colleague, Honorable Weziwe Dikana, tried to touch on this one, like when she made an example of the police and the wife, right? Because we've got people who are prohibited from doing business with the state, but they use family and they've got other proxies, right? And I just want to know, because the bill mentions employees, but we've got this common practice in, of public servants conducting business through their spouses, family members, and, other proxy companies and stuff like that. So I wanted to know if the definition of financial interest, covers these indirect interests. And maybe if, these can be detected, I don't know how. Do we have any mechanisms in place that can detect these if we've got, like, a Sikolise who is using a spouse, for instance, or another proxy, because it is a common practice as it is now. And so I just wanted clarity, maybe in as we are just interrogating this bill, Chair, if there is a way of maybe tying that loophole.
Okay, Chair, can I respond?
Yes, absolutely. Thank you.
Okay, thank you, Chair. Thank you, Honorable Member. Currently, the bill is only limited to public servant doing business with the state, but it doesn't extend to the proxy that your child, your partner cannot do business with the state. But in terms of you mentioned about the anti-corruption ethics, maybe that's the things that when we are going to draft the regulations, we'll have to look at that. If you are in the department, can your child or your partner have business where you are working? I think this is the things that we can look at as we are going to draft the regulations once it's enacted. Currently, it doesn't say much. It's silenced with the proxy people. Thank you, Chair.
Thank you very much. I see there's Honourable Kalise, there's you can proceed, and then there's another hand from the department after that. But
maybe the hands from the department wants to add what I said, Chair.
Yes, I think that's a good idea. But perhaps just maybe add. Thank you.
Yes, Rosita.
Thank you, Chair. Just to add on to what Dr. Foromo has said, so the clarity will come more with, and I know you were supposed to have a session with the lifestyle audit matters. So they will be able to touch more on the lifestyle audit procedure for regulations, and they will cover some of the issues that the honourable member have brought up. So that will put you in a more better informed position how they intend to deal with interests of spouses or partners or extended family members. But I can't speak to the content thereof, but Dr. Solomon Wagenrad Vermaak, it is his area of speciality, and you will get clarity when you'll have that engagement with them. Thank you.
Can I go on, Chair?
Yes, please proceed, Honourable Member.
Okay.
Thank you.
It's just one last one. I'm making my way to the house anyway, Chair. But I just wanted to maybe find out with the transfers or on the transfers, Chair, does the bill somehow have a way of preventing the abuse of these transfers? Because then now you find out that sometimes we've got transfers that are used as some form of punishment, right? You remove competent people or people that you don't like, and sometimes you even remove people just to make a way for the politically aligned, or you replace people with loyalists. So is there some way of ensuring that these are not abused, these transfers? Is there maybe some objective criteria, for transfers, and maybe who will oversee these things, like the legitimacy of them, and if there is a genuine reason behind the transfer? Thank you very much, Chair.
Okay. Can I respond, Chair?
Yes, please. Thank you.
I think when I was doing the presentation, Honourable Member, there was a reason for transfer, that it should be reasonable ground, and then the transferring executive authority must agree with the receiving one. And also the employees who wants to be transferred must give consent. If the employee is not happy, you can't force. So I think those are the reasons to prevent it. But when the three people agreed, it can open for abuse. If the transferring minister, the receiving minister, and the individual concerned, if they both agreed, but the ground is the one who is allowing the employees to go, the transfer should not actually open up a gap or shortage of skills where the employee is working currently. So there must be a reasonable ground as outlined in the Act to be able to say these are the grounds for transfer. So I think those are the only mechanisms that we have, Honorable Member, to prevent transfer or abusing or punishing an employees. Because if I'm not willing to go, I may not go. But if the system where I am, they are making my life difficult and intolerable, sometimes I can be pushed.
Baby.
I stop there.
Okay, attend the parliament meeting.
Thank you, Chair.
Lady Lesha, you're muted. Your microphone's on mute.
For the November. Before Guinea. Oh, and then.
Lady, please mute. Please mute. Please mute your microphone. Okay. All right. Thank you very much, Doctor. That was a good explanation. Is there any last comments, members, before we close the meeting? Thank you very much. I think that concludes our session then. I'd like to just thank the department for engaging us on these two bills. You know, we were in the position where they were not processed by our committee. They were processed by the committee of the Sixth Parliament, and we are all new members. So we really do welcome this opportunity to just see the technical changes and the important changes that have been made to both of these bills. And we look forward to engaging with at least one of the bills in Parliament, in the NA and in our committee. So thank you very much for the time that the department has given us today for this briefing. We do appreciate it. Members, that brings us to the end of our program for today. I will see most of you in the house later, and I wish everybody in the meeting a good day. The meeting is therefore adjourned. Thank you very much.
Thank you, Chair.
Thank you very much, Chair.
Thank you, Chair.
Thank you, Chair.
Recording stopped.